Hi everyone, my name is Ari Waldman. I am Michael Burstein's understudy. The slip of paper was slipped into your playbills early this morning. The role of Michael Burstein, unfortunately, will be played by me today. I'll be talking about a very different topic though. This project, Social Networks and IP, specifically focused on the public use bar, came out of my doctoral dissertation. I'm a privacy guy. I teach IP and I practice IP, and a lot of my scholarship kind of bridges the gap, but I do want to make clear up front, I am not a patent attorney. I never practiced patent law, and I don't like science. But this project this is one example of one project where I'm trying to bridge the divide between privacy and IP scholarship and IP doctrine, and in this case, IP practice. And the public use bar in patent law is the patent version of what I'll talk about today. Future, there are going to be applications of this on copyright and on trade secret. This project also talks about trade secret as well. So, my dissertation was on information disclosure. In the privacy context, how do we determine if information, how do we determine if information that is already known by certain other people, by just a few other people, if that information is public or if it's private. So subsequent to my dissertation, I'm applying it in various contexts, and one of them is the patent context. So how does public use case, public use bar is one of the policy levers that says, if you have disclosed or used your invention more than 1 year prior to patenting, you can't get a patent or your patent is invalid. So how does public use law determine the difference between a use that is public and a use that is non-public? It's the exact same determination that in privacy law we determine information that is out there. How do we determine if you have a reasonable expectation of privacy in that information, even though some other people know it? And then I asked, well, is that standard, whatever it is that the public use bar uses, is that standard evenly applied? My hypotheses were, given my research in privacy, was that that public use doctrine uses a standard privacy doctrine, what I call privacy as control, which is the idea that something is private if you retain control over that information to determine whether something is has been used publicly. So if it is out of your control more than 1 year prior to patenting, that is a public use, and therefore your patent will be invalid. And I also thought that given some inherent problems with a privacy as control model, that like the privacy context, the public use context would also apply that rule haphazardly. Because it doesn't really give you tools to determine what the line between public and private actually is. Unfortunately, that was supposed to be a drum roll, but the volume was down. Unfortunately, I was partly right and partly wrong. So it turns out that public use doctrine generally does apply a privacy as control standard to determine when pre-patenting use or display was public. So if the inventor retains control over her invention, however they determine that, then it's a non-public use. If she loses control, that's a public use. But with only a few exceptions, that standard is not applied haphazardly, it's applied discriminatorily. And it discriminates between these types of inventors, what I've clustered in the paper as cluster A inventors, the corporate inventors, and cluster B inventors. This is Flint Lockwood from Cloudy with a Chance of Meatballs. We contrast one type of inventor, the corporate inventor, the inventor, those 78% of inventions are given to employees of large firms who are employed to invent, and the hobbyist. A solo entrepreneur, the guy inventing in his or her garage. I put to one side the entire doctrine, the entire literature about whether the solo entrepreneur actually exists and the myth of the solo entrepreneur. There is a lot of evidence to suggest that there are a lot of inventors who do these, who invent things as a hobby. But that's not what this paper is about. I'm not kind of trying to justify whether these categories are fictions or actually really exist. They do exist in the sense that an IBM inventor is different than a guy in his garage. So when you cluster inventors along these lines, you get pretty stark results. These guys, Flints, tend to lose their public use cases. These guys tend to win. It's almost extraordinary how stark the relationship is. But once you go deeper than just who wins and who loses, you also learn that the doctrine is actually applied unevenly. So for cluster A inventors, corporate inventors, it doesn't matter if they have, so in all public use contexts, just to review, we're dealing with some pre-patenting disclosure. So some people, a small group maybe, know about your invention or have used your invention. So in many of those cases, corporate inventors get people to sign confidentiality agreements. So wherever you have a confidentiality agreement, generally, it's not always, but generally confidentiality agreements are privileged. If you have a confidentiality agreement, it's a non-public use. That rule, even though that's not what the doctrine is supposed to say, the doctrine says that a confidentiality agreement is just one of many factors. As applied, the Federal Circuit elevates the importance of confidentiality agreements, which indirectly benefits these guys. Because who are the ones that have the power and the money and the leverage to get their partners to sign confidentiality agreement? Only these guys, not these guys. In addition, a direct example of the Federal Circuit privileging cluster A corporate inventors is that where these guys have not signed confidentiality agreements, they're okay. They still win their public use cases because the Federal Circuit fills the gap by respecting the norms and customs of industry. It's just tradition that you don't talk about these things in this industry. And they say that's okay. You don't need a confidentiality agreement as long as these norms exist. These guys, no. These norms of confidentiality agreements among entrepreneurs, among friends, among students, among different types of inventors are not respected. And that's a stark difference. They never win. Cluster B inventors never win when they don't have except for one example. So I should say rarely win when they don't have confidentiality agreements. These guys almost always win even if they don't have confidentiality agreements. So that's the data. That's a stark revelation from looking at public use cases. And I think it's because, as I discuss in the paper, it's because of the use of privacy as control as the model, as the standard for determining when something is public and when something is not. So, oh, thank you. No, still not looking. Oh well. So as I explained, the courts unevenly apply or discriminatorily apply public use in two different ways, by privileging confidentiality agreements and only respecting the norms of industry, corporate entrepreneurs rather than solo entrepreneurs. So corporate inventors rather than solo entrepreneurs. But in all cases, the reason why they do this, the reason why they're able to do this is because when trying to draw the line between public and private, privacy is control. The idea that something is not public, as long as you retain control over it, doesn't give you any tools to determine where this line is. It allows you to just grow the public line or grow the private line without any explanation. So of course, inventors who are courts that are much more used to seeing corporate inventors are going to privilege the confidentiality norms and privilege those people that can get their partners to sign confidentiality agreements. So it's much easier for them to privilege, much easier than to side with corporate inventors than solo entrepreneurs. So we need to change the standard upon which the courts use to determine what's public and what's private in the public use context. One of the main problems with privacy as control is that it's all about the actions of the inventor, all about the actions of the disclosure. But an incident of disclosure is not an individualistic event. It's a social phenomenon. I am disclosing it to someone else. I disclose in particular contexts. This is what my dissertation was about. So if we disclose in a particular context, in context of what I talk about in the paper, social network trust, you feel comfortable disclosing to certain people but not others. We interact with our friends all the time like that. Then the standard we should use to determine when a use is public and not public should also reflect the social context of the particular use or disclosure. Currently, we don't do that. It's all about whether we got a confidentiality agreement signed or whether we retain control in some artificial way. So my proposal is to get us to determine when something is public or private based on the context. So as I said, it's an inherently social phenomenon. This is where social network theory and social trust come into play. And I go over this extensively in the paper. I don't want to spend a lot of time on it in the talk, just because it'll take us too far into sociology, and no lawyers are interested in that. But the idea is that social network theory, social network, we disclose information to different social networks because we interact with those social networks differently. Norms of trust and norms of confidentiality emerge in different social networks. And even though we're not corporate entities, and even though we don't have signed confidentiality agreements, confidentiality norms of social networks involving lone entrepreneurs can develop just as strongly as the confidentiality norms of corporate inventors. And there is no reason why the Federal Circuit and other federal courts should privilege one type of norm over the other. The only way that they can is that a flimsy doctrine like privacy is controlled gives them license. With a standard that employs social network theory that is about information diffusion from one network to the other, and trust, which determines when people share initially or why people would share in the first place, that gives them the tools to be able to say, all right, this particular disclosure, given the social context, is something that we could reasonably rely on would remain confidential. And that's not a haphazard standard. There are rules, there are sociological principles and studies done to show when something is going to diffuse. This is not my work, this is the work of sociologists and social network theorists. And that would provide judges with clear rules as to when something is public or private. And it would resolve this discrimination problem. And it would also advance the goals of patent law, because there is a whole wide swath of inventors being kept out of the innovation economy because their patents are either being taken away or they become much more expensive to defend, because the less likely it is that you're going to be able to test your invention or just demonstrate it before patenting, and the more uncertainty you have about the validity of your patent, the more expensive the whole ordeal becomes. So there's of course a lot more in the paper. I talk about social networks and IP generally, which is the subject of another paper of mine coming out soon. But I'd like to stop there and take your questions, because I certainly am, as a privacy guy, much more interested in your perspective.
I think this is very interesting, and I like that it's theoretically supported. I would just sort of suggest the administrability point. The confidentiality agreements is such a low cost proxy, and it's admittedly imperfect.
Right.
But from a societal standpoint, are we getting that much benefit by digging beneath that and providing all sorts of evidence of social context versus the cost?
Right, that's a great point. I address it a little bit in the paper in the section where I talk about responding to objections. Sure, it addresses the question of rules versus standards generally, and totality of the circumstances test versus bright line rules. As I try to state, the bright line rule that we have now is just a form of it was licensed to discriminate, and it results in it runs afoul of the goals of patent law to get people, all different types of people, to patent their information and to disclose their inventions, because this discourages lone entrepreneurs from using the patent system, so they'll go to trade secrecy instead. So I respond by saying not only is a bright line rule in this case harmful, I granted that a more flexible standard lacks the simplicity, but given the fact that public use incidents are social phenomena, they're about disclosure, they're meant to be decided on a case-by-case basis. So setting aside a general conversation about standards versus rules, in this context, I think the standard is better than a bright line rule because it's about contextual disclosure. I think I should emphasize that a little bit more, other than just in a paragraph in responding to objections. Thank you.
This is super interesting, and I do want to hear all that sociology stuff. That's what I do. But sort of two thoughts that may or may not be related. One is that the question of who's your in-group and who's your out-group gets very complicated when you start importing social network theory. And a firm is very easily defined. If you share with other people in the firm, they're in your in-group, everybody else isn't. Once you get out of that context, I think it gets difficult to operationalize. Maybe not. The other is, I would be very interested to see how experimental use factors into this. I was thinking about, for example, Luff versus Brunswick, there, he was engaged in experimental use, but he didn't have all of those formalities, the non-disclosure agreement, et cetera. And he would have had no other outlet for experimenting, whereas somebody working for a boat company would have been able to test it inside the company. So I suspect that you would find something similar with experimental use that you're finding here.
Absolutely, and as I talk about a little bit in the paper, the experimental use, I wanted to focus, just for simplicity of the contrast, I wanted to focus on public use generally, but of course experimental use it is so bound up with public use, and the difference is also stark. Solo entrepreneurs never win an experimental use claim. They say, or experimental use defense. And it's because, as you say, they have no outlet other than to actually test it on someone else's, and friends don't get friends to sign, friends don't let friends drink, nor do they let friends sign confidentiality agreements. So you're absolutely right on that, and I will emphasize that more in the paper. To the first comment, I think you're right. My study of social network, the study of information diffusion over social networks included a discussion on the business side of information, how information gets from employees to outside, and it's actually similar to individual social networks and the role of what sociologists call weak ties as opposed to very strong or close-knit ties. That it's the same operation. It still requires us to respond to the fact that what we're doing is we're asking judges to read sociology papers and try to figure out how these lines from node to nodes work. But I don't think that's a huge problem given that what the standard provides these general outlines for what kind of factors to consider. But that is a point about how information diffuses outside of firms that I do not address in the paper explicitly, and I will now. Thank you.
So I'm wondering if you've thought about other policy interventions you might use to get the solo inventors to act more like corporate ones, right? So I guess going back a little bit to Harry's point about let's get these corporate, these non-disclosure agreements used more widely, right? And so the PTO's pro bono patent program is one example.
Right.
Law schools are also starting entrepreneurship clinics
Right.
to do precisely this kind of work. So I'm wondering if you have any thoughts on those particular policy interventions or other things that we might do to improve or, to make the solo inventors look more like corporate ones, and if we want to do that.
Right, so
Yeah.
that's my point, and that's a great comment. I mentioned those programs specifically in the paper as evident, not in the context of these are other policy interventions, but that we already have evidence that the PTO is interested in helping out the lone inventor. So if this proposal ends up helping them out, it's not so far afield from the policy, the policy of the PTO. But to the second point, that's exactly what I think we don't want. I don't like the idea of using public use law as a kind of a paternalistic tool and say what corporate inventors do is right and what you do is wrong. The point is that the confidentiality norms of friends, for example, may be just as strong as the confidentiality norms of people working in the furniture industry. I don't know. It may be, it may not be on a given case-by-case basis. My point is that rather than encouraging solo entrepreneurs to have to look like corporate inventors because they don't have the money to pay lawyers, and they don't have the knowledge base of saying, oh, well, I really need this confidentiality agreement, that in fact that the law itself it embeds within it a kind of egalitarian principle that we should respect the confidentiality norms, and we're just not doing it because the standard that we use provides no guidelines. So I'm just providing the guidelines. So I think the second question that you asked is really the key. I don't want to have to force entrepreneurs to look like corporate inventors. We can disagree with that, and I've talked about that with some other people, but there's a social benefit to having them do their own thing and respecting their norms. Yeah.
Well, pessimist that I am, and I'll react to that a little bit. You suggest that the reliance on confidentiality agreements, in a sense, discriminates against the solo inventors because they don't have the wherewithal to get these things done. It occurs to me that one thing that also may be at work, apart from just whatever strength this large corporate behemoth has, is just that they have a stake in finding out the rules and can specialize in that and know what's required of them. It's a surprise to your garage inventor that there even is a public use bar. And so I wonder whether that sort of discrimination is inherent in having any rules at all,
rule in general,
or and particularly whether it's inherent in having a rule-like approach. So you sort of are, as you say, sort of advocating something more standard-like. Does the choice between rules and standards, if you're going to do one or the other, does that mirror the choice between favoring either the institutional and the big corporate ones who need certainty and stuff, versus the garage people who aren't going to know these formalities will get tripped up by them?
That's a great point, and economic analysis of law would accord because businesses make decisions based on legal certainty. More legal certainty decreases costs for the firm, so it makes sense that a rule that corporate entities would prefer rules versus to flexible standards. So and as a result, you suggest that therefore corporate entities have an interest in learning about these things so they can make profit maximizing decisions. I get that. I don't mean to put an economic language into your mouth, but it sounds like that's where it sounds like the theory accords. But I don't even if it's true that corporate entities just have an interest in researching what the rule is so they can make profit maximizing decisions, I don't think that's necessarily changes the analysis here, because then we have another example of how the law benefits corporate inventors because it's easier for them to research and easier for them to make profit maximizing decisions. So in that sense, I think that's another example. Maybe I should add that in, this kind of economic analysis as a way of showing how having a bright line rule, further privileges corporate inventors because they factor into their profit maximizing decisions. I don't know if I think you were offering a criticism, and I turned that into
not so much. It's just
I
an
turned
inherent
it
choice.
Yeah, I think you're right.
It's favor someone or the other.
Yeah, and one or the other there's always going to be a winner on one of that side, and corporate inventor is going to win when you choose a rule. There's a lot of scholarship on that in the business community. I guess this is just one tiny corner. Thank you. I think my time is up. But, thank you very much.